Good afternoon, everyone. This is Dan Frier. I'm one of the founding partners of Frier Levitt, and we are going to be presenting hopefully a very interesting and useful webinar for everyone who's in attendance. The webinar materials will be available after the fact. If you would like copies of them, you can just email a response to whoever sent you the original email, and we'll be happy to send you a copy. The two keynote speakers today will be Guillermo Beades and Theresa DiGuglielmo. Guillermo is a partner in the firm's healthcare litigation department. He co-chairs the firm's insurance defense group, and he represents healthcare professionals along a broad range of administrative, civil, and criminal healthcare matters. He has extensive litigation experience. He represents many practices who have been the subject of various audits, which he's going to get into in great detail. I could go on, but I think it's probably better if you hear directly from him. But he's certainly an impressive guy, and today happens to be his birthday, so you can all, you can all wish him in some way, shape, or form a happy birthday. Theresa has been with Frier Levitt for many years. She's senior counsel to the firm's healthcare department. She advises clients on a wide range of regulatory and transactional matters. And a part of what she does is very relevant to what we are talking about today. She deals a lot with Medicare provider enrollment issues, payer audits, and terminations. She's had a great deal of experience in the HHS OIG self-disclosure protocol, which is a very interesting topic and a specialty in and of itself. And although it is not Theresa's birthday today, you could still congratulate her if you'd like. With that being said, we'll start off with Guillermo, and any questions I'm going to be keeping track in the question box, and I'll try to get to them at the end of the webinar if I get a chance. If any questions aren't answered, you can ask them, and we'll try to answer them after the webinar.
All right. Thank you, Dan, for the introduction. So some of you, may have heard me, talk about audits and overpayment demands in the past, because it's something that I'm asked to speak about a lot because it keeps happening. And it's not necessarily getting better. It's sort of plateaued at this frenzy where we're seeing a lot of overpayment demands, a lot of document requests. We have a lot of practice coming to us now saying, hey, I thought Medicare was supposed to shut down audits during the pandemic, and SIOX keeps sending me 200 patient requests for audits. And it's something that, unfortunately, with healthcare being so highly regulated, it's among the most highly regulated industries in the country. I think next to like nuclear energy is, I think, the only one that has more regulations. It's just something that's easy pickings for auditors. It's found money. They've already paid that out. Now it's just money between the couch cushions, and they know from their experience from running Matrix who the most at-risk providers are and what the most at-risk codes are for being billed inappropriately or incorrectly. We'll talk a little bit about the different types of audits, private payer audits, CMS audits, but really the state of healthcare right now is state and federal governments are always, they're still going to be auditing you if you do a lot of pain management. If fraud, waste, and abuse is the #1 area, that generic catch-all term. And the reason is because the CMS comes out every couple of years with a new report saying how many billions and billions and billions of dollars is actually attributed to healthcare spending that's wasteful, that's medically unnecessary, that is upcoded, that is not medically reasonable. And that's something that they focus on because they know it's happening. And unfortunately, the smaller, less sophisticated practices are getting hit disproportionately hard because they don't have the same checks and balances. They don't have a billing department, a coding department, regular education. So our hope for you today is to try to demystify a little bit of it, not scare you, let you know that there's ways that you can and should respond to these requests. So moving on to slide 5, or slide 4, audits and document requests. So the three things I'd like everyone to focus on is, who, what, and why. Those are the three main areas when you get a letter. And it doesn't mean that everybody at the practice has to sit down and have a conference. You can just designate somebody. This is the person that if we get a letter from an insurance company that, an audit letter or request for documents, this person does it. It could be a practice manager, it could be one of the if you're in-house counsel. If you have somebody else like a doctor who wants to take care of that, they should do it. You need to understand who is requesting it, because the person signing their name at the bottom will tell you if it's an administrative request, civil, or worst case scenario, a criminal request, or tied to a criminal investigation where the practice may get swallowed up. Next slide. We're talking about, again, part of the who is, if it's CMS and private payers, we have a lot of practices who come to us saying, oh, we thought it was a routine audit, or we get audited all the time. They come to our, they ask us for records every year, every once in a while, and it's not a big deal. What was different about this one? And that's why you have to really look at what's going on. So as far as a targeted one, we'll talk about that one first. That's easy to see. Targeted is there's a suspicion of fraud, waste, or abuse. And you can tell by the language being used. They call you an outlier. They mention aberrant billing patterns. They will set you up in a way, but for this expectation that you're going to have to pay back money by including in the letter something to let you know it's going to be targeted. How do you know if it's targeted? How many records are they requesting? Is it 100 records, or is it 3 charts? Is it 10 charts? It's easy to discount a 3, 5, 10, 15 chart request as just being normal course of business. But there are some instances where we've seen firsthand where a low targeted amount of charts being requested is actually tied into another reason, which I'll have Theresa kind of jump in right now and kind of talk about a couple of experiences she had with what looked like routine audit.
Thank you, Guillermo. A lot of these audits arise in the context of a misused CPT code or modifier, and that's what we very commonly see. But we'd be remiss if we didn't also mention that we've seen some unusual circumstances, such as there was an instance in which a provider received a request for records during a very specific interval of time. They were 2 and 3 week increments. And what we later learned is that the billing provider of record was out of the country during those periods and had signed off on the records, professing that they had supervised the employee who furnished the service. So what we don't know is whether a disgruntled employee blew the whistle in that case, or if this provider was already under scrutiny by CMS. But what we know is that they had the information in advance, and they sent an ostensibly routine letter asking, can we see some records from this very discrete period of time? And that's what that turned out to be, a false claims allegation. It became quite serious, and there was a lot of money involved. Another instance involved a situation where a provider had seen married couples on the same date of service and furnished the precise treatment to each of them, the identical treatment, I should say, to each of them. So it appeared in that case that CMS was trying to paint the picture of a provider who had sort of indiscriminately ordered this test for everyone who walked through the door. And that request focused on married couples who showed up on the same date of service. So those are just 2 of many examples where we see something that is unique to the provider, not necessarily about a CPT code or a specific service.
Thanks, Theresa. Moving on to the next slide. The last thing is, we're not dealing so much with this in this presentation, but the other thing you need to be mindful of is who is requesting the records when it's a licensing board. If it's an investigator at the board, there's a deputy attorney general at the board, it could be in connection with a complaint, a pending complaint. or a referral from a state agency like, the state fraud division. The biggest thing to keep in mind with board requests and board matters, which again, board matters is another presentation all on its own right, is that you have in the state of New Jersey a duty to comply with any requests from the Board of Medical Examiners. With, you might be late on getting a record out to Horizon, you might ask them for an additional 2 weeks or a month, you might ask for rolling production. With the Board of Medical Examiners, it's a lot more rigid and it's a lot more difficult to navigate that space if you're missing deadlines early on, if you're not giving them all the records that they want. Because at the end of the day, they're not interested in your money, they're interested in protecting the public safety, and that means it's your license on the line. So just be very mindful if the WHO requesting records comes from an investigator at the state board. Moving on to the next slide about what are they requesting? Well, this goes to Teresa's point where look at the documents. You see a lot of requests where people are in the same family. We see that a lot in opioid cases, where a red flag is not just someone's coming in from 100 miles away for a pain doctor in South Jersey, but we'll also see multiple family members going to the same doctor. Look at the documents. You can tell a lot from that. Is it just purely E&M coding? Is it a specific procedure? In the world of CMS, and when we're talking about high reimbursement codes and procedures that might reimburse anywhere from $1,000 to $10,000, it's not uncommon to see an audit for 15, 20 charts from a UPIC auditor, and that ends up with a 6-figure overpayment demand because each date of service is really, really high. In that case, you're lucky that there's no extrapolation, because an extrapolation would have led to probably a 7-figure overpayment demand. But it's really shocking to doctors to see sometimes they only requested 3 months worth of records and I owe $120,000. Look at the records, make sure that the more specific the codes that they're requesting, get someone involved right away to start getting education, a corrective action plan in place. You need to understand what you're going up against. Talking a little more about what is the scope of the request? If you look at the next slide, you could have broad requests versus specific ones. Give me 50 dates of services or give me 50 patients, give me for 1 year worth of services. It's a little bit more difficult to figure that out. Sometimes the date range will be a 5-year range. Sometimes it'll be a 1-year range. And really the rule of thumb is 50, number of dates of service requested. If it's 50 and above, that's where I start getting worried about forming a statistically valid random sample. If you form a statistically valid random sample of claims, that allows you to extrapolate on your results. So you audit 50 charts, you find that there's a 100% error rate on a certain code. The practice was paid $1 million over the last 6 years in New Jersey based on that code. They're going to request $1 million back. And our firm has seen audits that are thankfully in the as little as 5-6 figures and then as high as 7. So the key takeaway is when you see that type of sampling, that's when you really need to start taking it very seriously, because you can't send in records that are missing anything. You have to understand that if you're sending in incomplete records and there's an extrapolation, they're going to come back with high error rates. You can't change anything, you can't add anything, but there are certain things you can do to ensure that you pass at a higher rate. And that's what our firm does. That's what the consultants that we work with, the expert coders we work with do. We try to minimize, exposure, and we also try to work through any potential issues with a corrective action plan, and then finally negotiate, the best outcome. Moving on to the next slide. So why? After you figure out who's requesting it, what they're requesting, why. All right, so we understand by now that the concept of a routine audit is less and less likely. Is it a post-payment audit? Did you get requests from something called a prepayment review? That's a new audit that's at least new in New Jersey. It's been around in other states, but Horizon NJ Health and Horizon Blue Cross Blue Shield in New Jersey, which are, you know, the gorilla in the room in New Jersey, they're the ones who just started using prepayment reviews. A prepayment review simply is a combination of a post-payment audit and a prepayment audit. Prepayment audit is simple. We don't think you know what you're doing when you're billing this code, doctor. Give me records after you bill the service within 15 days. If they're late, they're denied. Give it to me within 15 days. We will review it. We will get right back to you, maybe in 40 days. And then if that's approved, you'll get paid. Post-payment audit is, we want to review 50 of your charts, see if you've been billing it correctly. If you haven't, we're going to ask for some money back and go retroactively. A prepayment review is, we don't think you're billing this code right. Give us these records. Once we review enough of a sample of those records, we'll come up with an error rate and we'll treat it like a post-payment audit and go back 6 years. So it's very dangerous because it's been our experience that practices on the prepayment audit have issues complying with it because, one, they send records in and sometimes it's not timely, or they send records in but they get lost in, you know, all the running tubes that they have with records over at Verizon's headquarters, for instance. That's a situation where, you know, you need to get involved, you know, get someone involved on your behalf, advocating for you, making sure that records are being received by someone specifically at Horizon. And you got to make sure that not only are they receiving them, they're providing you feedback, because you, in a prepayment audit, you get a monthly report card that tells you how you're doing. In a prepayment review, that's handled by the SIU department, Special Investigations Unit. They handle fraud, waste, and abuse investigations. That's different than a prepayment department, which does none of that. The SIU doesn't give you report cards. The feedback's not as good. You don't get any feedback if you don't ask for it. So you need to be more proactive and get that feedback. And sometimes it does require, you know, legal intervention, because if you don't get feedback fast enough and they're just building up all these claims and the sample size, by the time you get that feedback, you're gonna get an overpayment demand shortly thereafter. The last thing I'll say about why is that it's a tough question to answer sometimes, because it can kick it's like, you know, playing tennis. You go over the net. It's like sometimes it might start at SIU as a civil matter, then it might become criminal, then it might go back to civil, then it might even hit it out of the court and say, nah, it's administrative. It doesn't even belong here. Many years ago, I represented a client who was the #1 biller, and if not #1, #2 biller, depending on insurance company, in the state of New York across multiple specialties. He was the #1 earner, #1 biller of certain codes. He dwarfed his competition. What happened was he went on prepayment audit because he put so many claims through and was doing so much work, they thought it was an impossible day. He was just billing too many services. What ended up happening is, you know, this doctor ended up going on a prepayment audit, and he didn't get out of prepayment audit for 2 years. Now, during that 2-year period, they were gathering data on him, they were getting information, and it got to the attention of an AUSA, who started looking at it as a potential criminal or civil matter, because when you're investigated by the federal government, it's parallel tracks. It's not, well, it's civil, or no, they're going on parallel tracks, and then at one point or another, the criminal side will say, all yours, or no, I'm going to take that, because they take precedent. What happened in this case is the criminal side said, we'll take over this case. They investigated the doctor for 10 years. They interviewed everybody they could that ever knew him, worked with him. They put a GPS tracking chip on his car. They tried to, they flipped his building company against him, and they did everything possible to try to set up a case of impossible day, the services not being provided, or worthless services because they're being provided too quickly. He ended up having to go to trial, and we represented him at trial, hung jury on the first trial, and a full acquittal on the second trial. But even in that second trial, while we were waiting, for the verdict to come in, the AUSA was serving us papers saying, we're going to freeze all those assets, we're going to force them to, sell everything. The government can really come after you hard. It can start as a prepayment audit, and worst case scenario, you end up losing almost 3 years of your life litigating a criminal defense trial like this one doctor. That is obviously the worst case scenario, but we've also seen other routine audits. I represent a lot of pediatricians. There was one that had to do with a pediatrician billing, a developmental testing code. A very typical error happened in this practice that I've seen happen at many practices, and it ended up with the matter being referred to the criminal division here in New Jersey. And we were able to avoid any criminal sanctions or any problem like that. But again, this is something that it was a problem I've seen before with pediatricians. It's a problem that's not, a $1 million issue. But again, you don't know how the investigator who's not knowledgeable about medicine or law is going to be treating your case. And when they see something, if you don't have someone advocating for you and sort of leading them, leading the horse to water, it's really it could backfire greatly. So you don't always know why, but treat it like it's a worst case scenario. Make sure you're clear, make sure when you send your records, and make sure that, of course, you send everything that you have to. So the next slide, I'll talk real quickly about some common misconceptions. I was at a dinner not too long ago with a group of doctors, and they blatantly asked me, what's the difference between a subpoena and a warrant? And that was kind of shocking to me because that's like lawyering 101, but that's like the questions I'm sure I ask my doctor when I go to her. She's probably like, how do you not know this? You don't know what you don't know. Very simple. If you ever receive a subpoena, contact an attorney right away. Don't answer anything, because with a subpoena, you have rights. You have a reasonable amount of time to respond. You don't have to talk to anyone. You may even be able to quash it, meaning get rid of it altogether. So you have a lot of rights with a subpoena. Any investigator, and there are some that do this, who comes in waving it like it's a warrant, saying, I have a subpoena, I need access to your EMR system right now. I need to print out records. You can tell them, that's great. Give me that. I'll have my lawyer call you by the end of the day. It's as simple as that. Subpoenas, you have rights. Warrants, you have the right to remain silent, and you probably should. So with a warrant, they need to be very specific as to what they're looking for, the area where it's going to be found. And again, you're not compelled to testify against yourself or to give any statement. So again, even though a warrant is a lot scarier, and it may lead to you being let out of the practice in cuffs, probably not going to happen. It's still something that's very scary. It can be intimidating, but please understand that they have the limitations too. And if you want counsel involved, you have the right to remain silent. And lastly, just because someone serves a warrant or subpoena on you, you never sign anything away. You don't give up your DEA license. You don't give up your CDS license. The one biggest misconception is that you think that investigators have a duty to tell you the truth. They don't. It's investigative techniques. They can say whatever they want to you. I've had countless practitioners tell me, I gave up my CDS because they told me I wasn't the subject of the investigation, and as soon as the investigation's over, I get my CDS back. That's not how it works. It's never been how it works. And once you give up your CDS or your DEA, it takes years to get it back. So again, trust your lawyers, be mindful of everyone else. The next slide More common mistakes, ignoring deadlines. If it's a CMS audit and you ignore a deadline, you may as well just hand them over a checkbook, because it is one of the few payers that will absolutely not give you an extension whatsoever. And good luck picking up a phone and calling someone and actually getting them to talk to you. If you can find someone, please contact me and give me their number. I've yet to find someone who will talk to me. Not keeping copies of records. This is a little more self-serving for me, I will say, but if one of my clients has had records copied, or they sent out records and they don't have a copy of what went out, it makes it much more difficult to defend and analyze going forward. Talking with investigators, again, just because they're there to copy records doesn't mean they're there to get a statement from you. A statement is completely different. Not sending complete records is also a big issue. Whatever is incomplete is denied. And then lastly, not sending legible records. You don't send legible records, again, they're going to get denied. You can transcribe them, but remember, transcription is word for word. We go to the next slide. So the last one about common mistakes. And I know there's a lot of slides about mistakes, but we see a lot of them, and we want to try to make sure that we see less of them. Again, treating all audits and document requests just like they're the same. If you see certain buzzwords, keywords, or if it's CMS, if they come with certain acronyms, that's that's what Teresa's going to talk about momentarily. That's one thing that you should get your ears up. Ignoring or missing keywords. Remember, if they're calling you an outlier in that letter, it's for a reason. It's because they've identified you as someone who's probably not doing something right. Not reviewing records before they go out. Again, don't send. This goes along the lines of sending illegible or incomplete records. You're only hurting yourself. And then allowing investigators unfettered access to your office or giving them statements. You want to avoid that as much as possible. Next slide. So how do you avoid some common pitfalls? Again, sit down with the letter. It's not going to take you an hour. Figure out who, what, why. You can't figure it out from the letter, send it to us. Well, I'll take a look at it free of charge, and I'll tell you, hey, you got a problem, or nah, you're fine. I mean, these letters, are pretty clear on their face, and you should be able to figure out, whether it's problematic or not. Also, never, ever, ever, I know they say never, never amend your records after you receive a document request from overpayment demand. You're going to say it's an amendment. Hey, I'm trying to explain something. I'm trying to, put color on the painting here. They're going to say it's an altered chart, which is a violation of regulations and is actually a crime. So we want to avoid that altogether. There are ways that we can explain things, and that's part of what our job is. And there's proper ways, if you needed to do an addendum or anything, or other ways that we can ameliorate something or clarify. And lastly, this is the last slide before I turn it over to Teresa. Audits, document requests, avoiding common pitfalls. This is one where, again, keep copies, have someone review everything before it goes out. I'll keep saying those because those are the two things that we see a lot that practices then kind of kick themselves in the behind for not doing. And, don't submit documents or give verbal statements. Again, there may be a time where we want you to sit down with a payer to explain your side of the story. But you have to understand that that's with us first, making sure that they understand who they're talking to, doing a little bit of work, making sure that what kind of questions you're going to anticipate. We'll treat it like a deposition almost. We'll prep you for it. That's fine to talk to them in that sense. But when your guard is down or when you're nervous and they're in your office, not the time to give statements. And again, no one to refer a matter out to counsel. I know sometimes the big concern is, hey, attorneys cost money and they're asking me for money. And, why do I want two costs? You'll see that, one, you may have coverage for it. You may not even have to pay counsel fees and expert fees. And two, it's about setting a precedent. And that's something that Teresa is going to talk to, and I will turn it over to her. Thank you.
Thanks, Jay. The who, what, why of this process is complicated by what we often refer to as the alphabet soup of contractors. We've listed a good deal of them here, just to give you a sense of how many there are and how confusing it may be for the average provider to receive correspondence and not know who's asking and for what and why. So the one that I'd like to zero in on here is called the Targeted Probe and Education Program, primarily because on its face, it's a helpful thing to a provider. It's educational in nature. It helps the provider to refine the coding practices and avoid some of these pitfalls. But in fact, having documented the education, the provider can get into some difficulties if following the education, there isn't that compliance. And Guillermo actually had an experience of a client who was the recipient of an educational session. I think you said 10 years ago, Guillermo, and then 5 years later again. To have them spread apart in this way is really a trap for the unwary, because if in between the compliance isn't tight, these TPA program reviews can escalate to further audits, prepayment reviews, and in the worst case scenario, ultimately a loss of billing privileges. Can you tell us about that case, Guillermo?
Sure. So the TPE is meant to basically be a follow-up audit once a practice has had maybe a large overpayment demand in the past, or billing errors and aberrancies have been discovered. So we're seeing it used improperly now, where it's just being used as another audit tool. And yeah, this practice, had a very thorough review. They had 100% passing rate, which is almost unheard of in a CMS audit. A few years later, they're audited again, 97% passing rate because they couldn't locate a chart. And then most recently, another one. And this one, we're fighting on because, the methodology was incorrect and everything, but it's really unbelievable how once you're a target, they come back. Now, not every year, every 3, 4, 5 years, it's them going back at practices who are potentially high risk or really high volume, particularly in a specialized setting.
And in the span of time you're describing, they're adding new providers who need to be on board with these compliance issues. So there are lots of potential impediments there. Next slide. So we find that some of our provider clients fall into some all or nothing thinking when they approach these audits, in that it's either a case of owing back money or not owing back money. In fact, there's a whole continuum of possibilities, ranging from an overpayment of 0 to potentially civil and criminal liability. So we like to approach it along that continuum and encourage a robust defense to mitigate the impact of the overpayment. And in the same way that the payors approach claims with that deny, reduce, delay kind of mantra, we kind of approach it similarly, and we encourage our clients to do the same. And I've indicated here a couple of those examples. By deny, I mean that the initial pushback can be demonstrating that the claim does in fact meet the conditions of coverage. Guillermo made an interesting point, which is that some of the investigators who do this work are not healthcare professionals. So they're reviewing claims, and I've had the experience of needing to educate them, whether it means getting the provider client involved, getting an expert involved, citing to professional journals. But it is sometimes the case that you have to educate them on the healthcare itself and explain it in great detail. That can be very powerful. And that's what I would describe as the deny portion of this, where we say, this inquiry is barking up the wrong tree, this provider did everything right, and there should be no overpayment. Reduce refers to the concept of, okay, we owe something, but we want to reduce it to the minimum. And if there are 2 CPT codes at issue and one of them should have been used, but the provider inadvertently upcoded. In this case, we're fighting for the differential between the codes because the service was provided, the patient benefited, and the physician has incurred unrecoverable costs in the provision of those services. So we typically at this level of pushback try to say, if we owe back money, it shouldn't be all of what you're asking, and here's why. And then finally, the delay concept is just that it can be a real imposition to return a lump sum of money, sometimes a significant amount. We have experienced during the past year in particular, practices hit so hard by the COVID-19 pandemic. And most of the payers have been accommodating of requests to pay over time. No one is getting away with not repaying a legitimate overpayment, but there's been some flexibility to acknowledge that it's difficult to make these payments. So we try to negotiate when an overpayment is due, some kind of an arrangement that is less impactful on the practice. Next slide. So when an overpayment is in fact the outcome of an audit and a demand letter is issued, it's really important to remember that that is considered a debt owed to the federal government. If it's not paid back, the payer, and I'm speaking now of CMS and commercial payers, have the same remedies in this regard where they can offset against future claims. And if there aren't claims to offset, it becomes essentially a collection action. So for CMS, that means the Department of Treasury gets involved, and it can escalate to a formal collection action and litigation. So never, ever ignore an overpayment demand. If you want to appeal, certainly competent healthcare counsel can help with that. We do it on a regular basis. But if the ultimate outcome is that an overpayment is owed, it cannot be ignored. Next slide. A question we get an awful lot is something Guillermo alluded to earlier, and that is, if I'm going to get stuck repaying money, does it really make sense to involve an attorney to push back? Ultimately, you may have to pay back some money, and the concern is that additionally there will be legal fees. We always say push back regardless. There are benefits to pushing back, not only reducing the overpayment amount, but clearing the record, ensuring that you defend your practices, pushing back to show you're not an easy target. There's precedential value in that, and also exhausting administrative remedies for future appeals. You can't get to an ALJ hearing unless you've gone through the other layers of appeal. So there's a stepwise process of documenting these efforts. Some people have coverage for audit defense such that their legal fees can be covered by their professional liability policy. But in either event, we're very experienced at working efficiently to help you push back and mount a robust defense that can mitigate the impact of this. These audits are potentially escalating into bigger things than just routine inquiries, and they really deserve the pushback. Next slide. So we really encourage internal audits as a proactive thing that practices should be doing. But it's often the case that an external audit by a third-party payer is the reason a provider starts to kind of look and say, it's time to check out what we're doing and maybe change our ways, implement corrective action. Sometimes these internal audits reveal issues that need to be addressed, such as a self-identified overpayment. You're obliged to return that money, but the manner in which you do it can be very important. It's not just a matter of putting a check in the mail. Sometimes we counsel clients to consider a formal self-disclosure process because that's an avenue to enjoy some legal protection from escalation. That's beyond the scope of today's webinar, but it's very frequently part of the counseling process when we talk about these internal audits. But in either case, all of it must be handled with care because as lawyers, we think a lot about unintended consequences. So you can really in good faith, very earnestly respond to an audit request and think that as long as I'm transparent and I don't alter the records and I provide them timely, no harm can come to me. But I think as Guillermo's presentation laid bare, from our experience, there are lots of traps for the unwary. It can, in fact, escalate into something bigger, and it's always valuable to push back. One of the other real life examples I wanted to mention occurred recently when a client was presented with an overpayment clawback of about $250,000, which, you know, frankly, in the age of COVID, I mean, it's real money in any time, but in the age of COVID was a big blow to this practice. And the choice at that juncture was, well, what do we do? We're frightened. It was a David and Goliath, the commercial payer versus the practice. And they really considered whether they should just agree to repay. In diving in, we found that there was just a bona fide ambiguity in the CPT code for the service at issue. And by pushing back, this payer ultimately admitted to us that there was indeed an ambiguity in the CPT code, that it was in fact a network-wide issue. Now, what is the significance of that? Every single enrolled provider in that specialty was making the same mistake with the CPT code, and they were going after all of them. But the payer admitted that there was no fraud or abuse, no indicia of that at all, but just this ambiguity in the code. The CPT code was changed actually to clarify that ambiguity, so it's no longer an issue. But all of these claims over the previous 6-year period were captured by the review process, which is all a long way of explaining that by pushing back, that practice ultimately is repaying under $100,000 versus the original $250,000. I say this not because a 6-figure clawback is a small thing. It was still a challenge for the practice, but had they just been scared and returned the money, they would have grossly overpaid, because the payer just generally doesn't go to the provider and say, we're open to negotiation, how about you pay less? If they can start big and shake the tree and get all of that money back, they will do it. So our message is always push back. It's always worth it. And that's a perfect example of a case where they could have overpaid by an awful lot. Next slide. So I think we've made pretty clear that even a routine audit can have very serious consequences. Handling it in-house can be very costly. Our clients who engage us for help with this process often find that they can mitigate the impact very meaningfully. Guillermo, can you comment on the kind of coverage that some professional liability carriers provide for audit defense?
Yes. Many companies, particularly here in New Jersey, will have an administrative rider to the medical malpractice insurance policies, or it might be another part of the medical malpractice policy, where they afford coverage for billing errors and omissions. We've seen that applied to overpayment demands, significant record requests, particularly where there's that potential for, a pending overpayment demand. And the reason why a lot of times, insurance companies will offer coverage when maybe 100 or 200 charts are being requested is because they understand that timeliness is an issue. You have to get the records over to the investigator within 30, 45 days. They get to sit on it and review them for 6 months to a year, sometimes 2. And then when they give you their findings, they expect you to give them a response in 30 days, or they'll start a collection action, or so you can't get retained once that overpayment demand comes in. It has to be well before that. And a lot of insurance companies will offer coverage to pay for both counsel fees and expert costs, and that's usually a certified professional coder. In limited circumstances, we might get a statistician to challenge a a sampling issue, if we don't think it's a statistically valid random sample. But that's typically something that, we see.
Another common question that comes up in the context of CMS and commercial payer audits is this notion that because the payer has reimbursed these claims over a period of years, that somehow it feels like entrapment to the provider that they're suddenly wanting to claw them back. Like, I submitted these claims and I was paid. Doesn't that validate that I was doing the right thing? And one of the coding consultants with whom we work is pretty well known for saying it's easier to get paid than to stay paid, which for any of us who work in this space is a very true statement. The fact that the payer issues the reimbursement is not, in fact, comfort or validation that they agree with the manner in which the claim was submitted. They have this right to go back and review it. So that mantra is always in my head when I approach these matters, that yes, you got paid, but with my help, hopefully, you'll stay paid, or as paid as possible, so to speak.
Thank you. That was fantastic, and I appreciate it. There are no actual questions because you did such a thorough job, but I do have a question. I have a point that I thought maybe we could underscore. Guillermo, you and I have had some experience with this, but it might be worthwhile mentioning that payers have challenged payments not based upon medical necessity or upcoding or the billing for service that weren't performed or inappropriateness of the service, but rather the underlying structure of a business, the underlying structure of a practice. And maybe you could speak to that, both of you, just for a couple minutes.
Sure. What I'll say quickly about that is that it has become quite an area of subspecialty for me, which is the onslaught of federal cases being filed by Geico in particular. At the state level, it's Allstate who's filing them, and they're mostly based off of PIP claims. So they go after chiropractors, PT, orthopedists, pain management. It's a situation where they're focusing a lot on New Jersey's Cody law. They think that because a referral is being made from one practice to an ambulatory surgery center where one of the physicians is an owner of both, that it taints every claim by everyone for every service. And these cases, like I said, Geico is probably the number one company doing this right now, and they're at a feverish pace. They probably have 50 of these cases nationwide. Big focus on New Jersey and New York, and particular focus on anyone who's involved in PIP, obviously. So if you're involved in PIP, or if you have insureds, that are involved in PIP, this is a big area to make sure that their contracts are compliant. I don't know if Theresa want to speak about that a little too.
I would just add to that, Guillermo, that people are familiar with the corporate practice of medicine doctrine generally, but many have not really seen it in action. And this scenario is exactly that, where the prohibition on the corporate practice of medicine really comes to life in this setting, where a layperson or a lower level licensee who is not permitted to own a medical practice exerts too much control over the practice, whether by way of a direct ownership, which is inappropriate, or by managing it in such a way that the layperson or the lower level licensee is a de facto shareholder of the medical practice. So when that occurs, the insurers are challenging the underlying professional practice structure. They don't have to talk about CPT codes or medical necessity or any of the things we've discussed on today's webinar when auditing these claims. They're just straight up saying an illegal entity submitted this claim and therefore we're not honoring it. It's a pretty a pretty strong tool in their toolbox to push back on reimbursements, to claw back millions of dollars. And we counsel clients always to be mindful of that corporate practice of medicine prohibition for that reason.
So I think it's corporate practice of medicine can expose you, violations of Cody law because you have other entities that you're making referrals to in a way that doesn't meet a Cody exception. We've seen many of these practice arrangements set up by attorneys that are not necessarily that experienced with some of the transactional and regulatory requirements. And without obviously, naming names, there are instances where attorneys that are specifically focused on PIP arbitrations and are very good at that work sometimes get into trouble because they're advising on regulatory issues that they're not as comfortable with. I'm saying this because it's such a huge issue out there right now, and there's millions of dollars at stake. You could literally get recoupment of all the work you've done for a carrier for the last several years. Just it's a travesty, but the insurance industry has got a powerful lobby and they're able to do it. We do have one question. I'll ask it, and then maybe the panel can answer it. The question is, are there any notable considerations that are unique to audits by private payers of billings submitted for out-of-network providers? And the answer is definitely, emphatically, yes. Out-of-network billing is unique. Maybe Guillermo, you can speak to that a bit.
Yeah, depending on what the service is, was it a hospital setting? Does it fall under, the out-of-network laws requirements, or at least does it avail you to the out-of-network laws arbitration provision, where you can go arbitrate in front of Maximus? Are they denying the claim, or are they just severely underpaying you? That's an area where, yes, it's far more intricate in that sense. As far as overpayment demands and everything, they still have the right, just like if you were a participating provider, to audit you, to get records. But as far as non-payments, underpayments, and things of that nature, we see that a lot with out-of-network providers. And what we'd like to do is try to get them to Maximus here in New Jersey for the arbitration process, because there was an article not too long ago, I don't know if it was Modern Healthcare or another legitimate healthcare publication that noted that when providers fight these, when they take them to arbitration, the early results have been that more often than not, I think something like 60 or 70% of the time, the doctors win, because basically it's a type of arbitration where the doctor puts up a number and the insurance company puts up a number, and there's no negotiation. The arbitrator is going to pick one, and usually the insurance company is too low, too greedy. So if you come in with something reasonable, you can win. So we help physicians navigate that, particularly the arbitration process. And there's some prerequisites to even get to arbitration. There's definitely intricacies, and I'm more than happy to discuss that further offline.
The other thing I'll mention about out-of-network billing is we're trying to develop a model to help out-of-network practices by actually representing their patients. And it's an interesting program that we're developing, because patients have very, very specific and direct rights. Whereas, for example, patients have to assign their benefits over to a provider, and many of the payers have anti-assignment provisions that can be challenging. And there's an arbitration process, which can also be lopsided in favor of insurance companies. If we represent the patients, sometimes even in a consolidated or a class action, if we're talking about a substantial amount of money that's at stake, we feel that there may be a more direct source for getting compensation for physicians. So if you have any questions about that, you can just reach out to any of us on this panel. And I think that's it, unless there's any additional words of wisdom that Guillermo or Theresa have. Oh, you know what? Yeah. So someone said, "Can we get your presentation slides?" I mentioned in the very beginning, if you'd like the slides, just respond to whoever sent you the original email, and they will send you a copy of the slides for your information. Thank you, everyone, and have a great day. Stay safe.
Thanks, everyone.
Thank you.